Welcome to today's program, How Multi-Jurisdictional Businesses Should Approach Non-Competes. Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you will be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the chat box on your screen. Now I'd like to turn it over to Dawn Mertenite and Robin Marsh.
Thank you, Colleen. My name is Dawn Mertenite. I'm a partner in the Boston office here at Seyfarth, and with me, as you can see, is Robin Marsh, an associate in Chicago. Robin and I are both members of Seyfarth's Trade Secrets and Non-Compete group here at Seyfarth, and we have been working in this area for many, many years, advising clients and litigating disputes in this area. So we're happy to have you here. We think this is an important topic and hopefully will be really informative for you. So let's first take just a very quick look at our agenda for the day. First, we're going to do a very, very high level discussion of the non-compete landscape. As many of you know, there's a lot of differences in state laws, so we'll talk a little bit about that. And then we'll really get into the meat of the presentation by talking about various strategies for creating an agreement that will comply with all these various state laws across the United States. And then Robin will be talking a little bit about how to implement any new agreement that you have and what will happen if you have unenforceable provisions in your agreement. And then finally, if we have time, we will take some questions. If we don't have time, you can still type your questions in. We will do our best to get back to you in the next couple of days and provide a response to your questions. So without further ado, let's look at our first topic. The state laws, as you know, as I just mentioned, the states have a wide variety of laws on restrictive covenants and non-competes specifically. Generally speaking, however, in states where non-competes are enforceable, you want to see three basic things. First, non-competes and other restrictive covenants need to be supported by adequate consideration. Now, this is not the peppercorn of consideration that you may recall from law school. It really needs to be something more substantial. And then second, the non-compete needs to promote a legitimate business interest. And this may vary a little bit by state, but generally speaking, in all states, a legitimate business interest is protection of confidential information, trade secrets, or customer goodwill. And again, there may be some other special state rules on that, but those are the main ones that we tend to see. And then finally, the restrictive covenant should be reasonably limited, and we'll talk about that a bit. And in fact, I'm going to talk just very briefly about the sorts of limitations that we typically see. You'll see here time, activity, and geography. So time, your non-compete has to have a duration, of course. The activity, it needs to describe what is being prohibited, whether it's not performing certain work for specific customers or something broader than that. In my view, gone are the days that your non-compete could simply say that you won't join a competitor because perhaps that prohibits an employee from doing something that really isn't competitive with what they were doing for their former employer. And then finally, geographic or customer restrictions. We do sometimes see worldwide or nationwide geographic scopes, but typically we expect to see some sort of limitation there. So let's move on to the next slide. So again, many states have statutes, and I'll tell you that in my experience, the last 10 years or so have really been remarkable when it comes to how much legislative action we have seen, especially compared to the periods before that. I mean, it's just bill after bill, and things are changing all of the time. So we need to be very mindful of those new state laws as they come about. Not every state, however, has a non-compete statute. Some states have common law rules that developed through court decisions, but those will still guide our approach to a non-compete agreement or other restrictive covenants. So some things to consider that we have seen more recently in the last few years of the increased legislation. More and more states are considering non-compete bans along the lines of California. For example, right now there is a bill being discussed in New Jersey that would ban non-competes. Hasn't passed yet. We don't know if it will pass, but that's something to be mindful of. Next, you'll see we've talked here about choice of law and forum selection clauses. We will talk about that a little bit more, so I'm going to put a pin in that. Similarly, penalties for failure to comply with a statute. This is going to be something that we will talk about further in the presentation, but it's essentially the idea of what happens when your agreement is deemed too broad. Will it just be unenforceable, or will the company have some liability or have to pay fines or something like that? Another thing that we are seeing very frequently with new laws in these various states is an explicit requirement that the employer advise the employee that they have the right to counsel to review the agreement before they are required to execute it. Similarly, notice requirements. The idea here is that you don't necessarily want the employer to ambush somebody on the first day at the job and say, hey, now you're with us and you have to sign this agreement or you're going to be fired. So a lot of states have rules as to when the agreement must be handed out to the employee or prospective employee, and those differ greatly. Reformation versus blue pencil versus red pencil. Again, Robin is going to talk about this in a bit. What can a court do if a judge determines that your non-compete is too broad? Can it limit it, or will it strike it entirely, or some other penalty? And then finally, continued employment versus additional consideration for existing employees. As you may know, many states, I would say probably about half at this point, require some additional consideration if an employer is going to hand out an agreement to an employee who's already an existing employee. So that could be in the form of a raise, a bonus, some other form of consideration. So that's something to be mindful of as well when drafting these agreements. Next slide, please. So I want to be clear here that these are only examples. We have not listed every single state that has quirks on this slide, but this again will give you kind of a sense of where things stand. On the leftmost column, you'll see the states that prohibit non-competes. California, North Dakota, Oklahoma are very clear. I did include Nebraska here. Nebraska, if you look at the case law and the statutes, there isn't a clear prohibition on non-competes. But the states where the court is saying we are enforcing this non-compete, what they're really enforcing is a customer non-solicit. So in practice, I really think that Nebraska has essentially prohibited non-competes. In the middle column here, you can see just a sampling of states that have some quirky rules. So you can see again, in a lot of these, there are compensation thresholds. So employees under a certain salary level can't be bound by a non-compete. There are notice requirements, as I just mentioned, right to counsel, so on and so forth. And then finally, in the last column, you see the states without major restrictions. Now, I want to be clear that this doesn't mean that you can just ignore these states. And again, Robin is going to talk a little bit later about reformation versus blue pencil. You want to make sure that your agreements are drafted with those rules in mind. And so you don't have an overly broad agreement for one of these states that might limit what a judge can do if there's an overbroad agreement. But these don't have quite as many of those quirky rules about notice requirements, right to counsel, fee shifting, and the like. Next slide, please. So here's where we're just going to give a little plug for our 50-state desktop survey reference guide. As you can see, we list all the states, and it would be impossible to have in this little guide every single rule for all of the states, but we highlight the main third rails, if you will, the various rules and restrictions that you need to be mindful of. Now, as I mentioned at the top of the hour, this area of the law is changing so quickly that this will change, and in fact, we do have a new version that we are finalizing. It should be ready for publication in the next several weeks. So keep an eye on that. You can get access to this document. There's going to be a link in the email that goes out after this where you can download it. So keep an eye on that. All right, so now let's get into the real meat and potatoes here, the strategies for complying with all these various state laws. So we often have clients come to us and ask, how can we possibly create an agreement that takes into consideration all of these various rules? You know, there's so many confusing, contradicting rules in the various states. There's potential liability in some states. So here's kind of a checklist of what we go through first when we are trying to help our clients with these. So first and foremost, where is the company's principal place of business and where is its state of incorporation? Obviously, for the latter, many clients are incorporated in Delaware, but not all. And those questions are going to be important in determining what state laws will be implicated. Next, do you have employees across multiple jurisdictions? For the people who are on this webinar, I'm guessing the answer is yes, otherwise you probably wouldn't be here, but this is something that's really important to think about. Where is your workforce? And even if you just have a handful of employees or even a single employee in certain jurisdictions, how is that going to impact your restrictive covenant enforcement and plan? The next question you'll see here, do you have employees who live in one jurisdiction but primarily work in another? This is important, and I'll give you an example why. In Massachusetts, we have a statute that was passed in October of 2018, and it sets forth a number of rules that have changed the previous common law. And interestingly, this statute purports to apply to individuals who both live or work primarily in the Commonwealth of Massachusetts, at least for the last 30 days of their employment. So you could have a resident of New Hampshire who has never lived in Massachusetts, but every day or 2 days a week, they're crossing the border and coming to their office in Massachusetts. Under our statute, that New Hampshire resident should be governed or should have the protections of Massachusetts law. Similar question for employees that work remotely. You might have an employee who's sitting in Minnesota, but they're working for Massachusetts, a Massachusetts company. They're working with the Massachusetts division. You know, even though they're in Minnesota, they might be closer to the Illinois office. They're really doing their work for the Massachusetts office. So in that case, you would still want that person governed by the protections of Massachusetts law. So you need to think about where people are sitting, who they're working for, whether they're working remotely. The next thing to consider is the assets that you're seeking to protect. As I mentioned earlier, the non-compete needs to be supported by some legitimate business interests. So this is another thing you want to consider when determining what state laws are going to be implicated here. Next, what levels of restrictive covenants are needed? This is really important too, and it can be complex because many of our clients have different tiers. So you might have people in the C-suite or vice presidents or other people who are senior management that you really want them to be bound by a non-compete. But the rank and file, you know, the people who are, you know, first year employees straight out of college who might not have some meaty role, not getting as much access to confidential information, you might decide that that person doesn't need a non-compete. They only need a non-disclosure agreement, or, you know, maybe a non-disclosure and a non-solicit. Or it could be that you're in a state where whether you want that person signed up to a non-compete or not, they're not allowed to be because their salary, for example, is underneath the threshold. So that's another thing you want to think about. Do you want to have in one agreement the various tiers, or do you want to have separate agreements? So one agreement will go to the CEO and another agreement will go to the college graduate that you just hired. Additional consideration, as I mentioned earlier, in about half the states, for existing employees, you will need to roll out a new agreement with some additional consideration for that agreement to be enforceable. It could be a raise, a bonus, increased access to confidential information or customers, but that's another thing you need to be thinking of. Is this agreement that we're seeking to apply to the entire workforce, is it only going to be rolled up to new employees, or are we going to also roll it out to existing employees, and what does that mean? So then, taking into consideration all of these questions, what are the state laws that are impacted and implicated by all those questions? Finally, I have here, what is the company's risk tolerance? I personally think that this is a really important question. And the reason for that is that we have a number of different buckets of states, if you will. So as I mentioned, there are a number of states that have some quirky rules, but it may be that in those states, if you don't comply with those rules, the worst that happens is the non-compete is unenforceable. And then in contrast, you have a growing number of states where the worst that can happen is the company is required to pay the employee's attorney's fees or pay certain fines, or they might be subject to some investigative situation with a state attorney general. Now, for some clients, they say, you know what, our risk tolerance is pretty high. We understand that this agreement, it's pretty streamlined. It's fairly short. It's not terribly lengthy. It's not 10 pages long. And we know going into this, even, taking aside the issue of whether you get a judge who's particularly hostile to non-competes or you just have a bad set of facts, we know that certain employees in our workforce are not going to be bound by this agreement. We're going to roll it out to them. We're going to ask them to sign it, and it's not going to be enforceable against them. For example, we're asking someone to sign this when they're below the salary threshold. So we know we can't enforce it, and that's fine with us. We're comfortable with that. We know it going in. We rather would have a streamlined agreement. Other clients, as you can imagine, feel the opposite way. If we're going through this process, if we're asking people to sign it, we want it to be enforceable. So let's include all of the bells and whistles. Even if we're not worried about liability, we want to make sure going into this that this non-compete is as enforceable as it possibly can be. So let's look at the next slide. So again, in the states where non-competes are enforceable, there are certain things that you need to make sure occur regardless. As I mentioned, consideration is a big piece of this. We often think about financial consideration. So the person's salary, any raise or bonus they might get, benefits, but there are other types of consideration that you should consider. And in your agreement, you should specify that that is part of the consideration. So you'll see specialized training here. Sometimes that can be consideration. Access to confidential information or trade secrets, and access to customers. So that would be access to the goodwill. You also want to have a duration, as I mentioned. You'll see we have here 6 months versus 5 years. The type of agreement that you're using will dictate what is reasonable. So in the case of a sale of a business, let's say a family business sells their company, and as a result of that, they're required to sign a non-compete so that they can't just turn around and then steal all their customers and have their name out in the public. That's something that a multiple year non-compete might be reasonable. But as you may know, for most garden variety employment agreements, a 5-year non-compete is not going to work. And in fact, I would say in my experience, 2 years is maybe the max. Even that is pretty tough. 6 months to a year is really what we're seeing. And in fact, some states are requiring no more than a year. Scope of employment. Again, you need to specify what is being prohibited. And that is going to depend on what the employee's role was with the company before they left. You'll see, I mentioned here, look back periods. The reason we talk about that, even though it's becoming less common, there are people who stay at the same workplace for 30 years. So what somebody was doing as a first year post-grad 30 years ago, that might be very, very different from what they're doing now. Maybe they were in sales when they first graduated in the 1990s, but now they're doing something completely different. Most judges are going to expect that when you're prohibiting that person from doing a certain type of work after they leave, that it has some reasonable tie to what they have done for the last couple of years. So usually our look back periods, we say 1 to 2 years. You're not going to look back to what somebody did 15 years ago and say that they can't do that anymore if they haven't done that work in the last 15 years. And then finally, geography, as I said, sometimes we do see nationwide or even worldwide non-competes, but typically courts are going to want to see that these are reasonably limited in light of the person's role with the company and where they're working. So moving on from there, this is the question that we get a lot, and it's one of the reasons we're having this webinar. Can you have one agreement or do you need multiple agreements? So you can have one agreement that really covers all 50 states. It can get tricky, and we recommend that you talk to trusted counselors about that, but it is possible. So the question is, which is better? Well, I'm going to skip forward and spoil it for you. There's no right answer here. It really depends on your business. And I'll give you some examples of the pros and cons. So as I mentioned, you can do it in one agreement. And typically what we see in that scenario is you have all of your provisions, and then there's a section, whether directly after the restrictive covenant section or maybe near the end of the agreement, that includes various carve-outs or additional acknowledgments. So it will say if you're a California employee, this section will not apply to you. If you're an Illinois employee, this section will only apply to you if, A, B, C, D requirements are met. So you can do that. Some employers prefer that approach because it's easier. You only have one agreement. You don't need to worry about the administrative headache of making sure somebody gets the right agreement. Now, on the flip side, you can have multiple agreements. So we have clients who say, you know what, I want a whole separate agreement for my California employees. That's going to be very different from what the vast majority of our employees are going to get. And that's fine. And part of the reason some clients prefer that is because they don't necessarily want their employees in Minnesota saying, wait a second, why does my buddy out in California get a carve out to all of these, but I'm still bound by this? That doesn't seem fair. So that's one reason that some of our clients do want to have multiple agreements. Now, I should point out that if you go the multiple agreement route, it doesn't have to be a separate agreement for each state. There are a lot of states that are treated more or less similarly. So you can have an agreement that covers, a dozen, maybe 20 states, and then you have some separate other agreements that cover 3 states, California, this, that, or the other. One other thing I should mention here, there is a hybrid approach that we can take, which is to have a main agreement and then an addendum that is state specific. And so again, you do have the administrative piece of making sure that the employee gets the right addendum. So it's not quite as easy to roll out as the one agreement, but at least you're not dealing with, 15 separate agreements. So that's one thing that we see pretty frequently. Again, it may be that you want separate sets of agreements for different levels of employees. So, new employees versus existing employees, or senior managers versus the rank and file. That's something to consider. We can do it all in one. It makes it a little bit less streamlined, but it's possible. And on the flip side, if you don't want that, if you'd rather have it, much more streamlined per agreement, we can separate those out. The last thing I have here under the question section is, do I need to include a choice of law or venue provision? So this is something I'm going to put a pin in because we are going to talk about it in a few slides. But this is, for, as far as I'm concerned, this is one of the big issues that we need to grapple with because more and more states are addressing choice of law and venue provisions. So let's go to the next slide. I'm not going to read all of this text, just so you know, but we wanted to provide you an example of what this might look like in the various permutations that I was just talking about. So in the bolded language above, we have, the standard non-compete language that you might see in an agreement, which it basically says that the employee agrees for a year after they leave the company, they won't compete, they won't engage in competing business, which will be defined elsewhere. Now, for states where you need some sort of exception or additional requirements, you can see here, we have an exception example for employees that are California-based. This section won't apply after their termination, and the section on choice of law and venue won't apply. And then in other states where we still want that to apply, but want some additional acknowledgments, you have an example of Illinois here. The employee is acknowledging that they make more than $75,000 annually. They acknowledge that they were given at least 14 days notice to review, and so on and so forth. So that's an example of what you might see if you want one single document. If we go to the next slide, you can see an example of what an addendum would look like. So again, you'd have your main document that has all the provisions, and then you'd have a separate piece of paper that would go after it that would only go to those employees who live in Oregon, as you see here, or who work primarily in Oregon. And this, much like the last slide we saw, it does provide the extra bells and whistles that we need to comply with to have a non-compete be enforceable under Oregon law. Next slide, please. So this is the last thing that I will tackle before I hand it over to Robin. As I mentioned earlier, choice of law and forum provisions this can be really tricky. It used to be the case that a lot of employers would try to get around some of the state-specific quirks by simply having their agreements governed by a certain state's law. So for example, let's say you have lots of employees in California where, generally speaking, with very, very limited exceptions, non-competes and non-solicits are not enforceable. Many years ago, you might have had an employer say, that's fine, we're going to have our agreement governed by Delaware law, where non-competes and non-solicits are enforceable. Well, legislatures got around to realizing that that was going to be an issue and that their constituents might be bound by agreements that they didn't agree with because of this choice of law issue. So we're seeing more and more states implementing these rules. And in this slide and the next one, I'm going to talk briefly about 5 states that have such rules. So California, again, this is the most onerous state as far as restrictive covenants goes. For all agreements dated on or after January 1st, 2017, Labor Code Section 925 prohibits the use of law other than California law for restrictive covenants agreements. Now, there are very, very limited circumstances where you can get an exception. I won't go into all of that except to say that in order to get an exception, the individual employee must have their own counsel negotiating the agreement. So it's going to be tough to find an employee's lawyer who will agree to some other state's law. But just so you know that there is an exception, but it's pretty difficult to meet the circumstances for that. And what's concerning about this is that, as you can see on the next bullet point, failure to comply with that rule may result in fee shifting. So let's say you have an employee who's based in California. There's not an exception to this 925. You have them sign an agreement that's governed by Delaware law. If there's a lawsuit between the company and the employee may be entitled to retrieve his or her attorney's fees from the company. So that is something to be considerate of, and it is something that we include in our agreements to make sure that we're not running afoul of that rule. Colorado, this is a relatively recent new change. Similarly, it requires Colorado choice of law and forum for employees who are residing in and primarily working in Colorado. Now, one thing I want to note here that's a little bit unique about Colorado, in most cases when we look at choice of law and venue provisions, courts will analyze those provisions as of the date of execution, because as we know, lots of people move around. They might live in California one day and then move to Minnesota the next day. Colorado is interesting because the statute requires that you look at the employee's location at the time of termination of their employment, not when they signed the agreement. So that is something to be mindful of. Next, Louisiana. Louisiana is one of those states that does generally prohibit out-of-state governing law or forum selection provisions. It does not, at least as of right now, it does not have any real penalties for failure to comply with this, other than the agreement will likely be governed by Louisiana law and a case will likely be transferred to Louisiana. So you still want to have in mind, if you have an agreement that doesn't carve out the choice of law for Louisiana residents, you still want the rest of the agreement to comply with Louisiana law in case litigation comes to fruition and then a court determines that Louisiana law should apply. So then finally, the last 2 states that I will mention this issue on, Massachusetts, as I mentioned earlier, we have a statute that was passed in 2018, and the statute requires that for either employees who live or work predominantly in the Commonwealth for the last 30 days at least of their employment, their agreements must be governed by Massachusetts law and litigation must occur in Massachusetts. Now, this is a provision that doesn't really have any teeth if you don't include the Massachusetts law or forum selection. The worst that's going to happen, most likely, is a judge is going to say, yeah, I don't think Delaware law should apply here, so I'm going to apply Massachusetts law. But there won't be financial penalties, at least under the existing statutory scheme. And one other thing I wanted to mention, at least with respect to the forum selection clause, this has been called into question by at least one federal court. There's actually 2 courts that have dealt with this, where the federal court has said you know, it's great that Massachusetts legislatures included this provision, but in federal court, we have a policy of enforcing mandatory forum selection clauses, except in extreme circumstances. So, you know, despite the fact that the legislators in Massachusetts think that this is important, it's not such a fundamental policy of the Commonwealth that we need to ignore the forum selection clause, putting this litigation in Virginia or Connecticut, as the case may be. Finally, Washington also has one of these provisions that you need to be mindful of, especially because, like California, there are severe penalties for failure to comply with this. The statute requires that a non-Washington forum or a choice of law that deprives the individual of protections of Washington law is void and unenforceable for Washington-based individuals. And this does have a statutory penalty. It does have fee shifting for failure to comply with this. One thing I'll note real quickly before turning it over, again, the statute says that the choice of law can't deprive the individual of the protections of Washington law. As I read that, that doesn't require Washington law to apply. You could have California law apply because California law is more pro-employee than Washington law. So you're not depriving the employee of any Washington-based protections by having them governed by California law. If anything, they're getting more protections. But in any event, you need to be very careful if you are applying a law that does not provide as many protections for employees. So with that, we're going to turn it over to Robin for the remainder.
Thank you, Dawn. Arguably, one of the most important things that we will be talking about in this webinar is the CLE code, which I have been gifted with giving it to you. So when you receive the CLE code, you'll also receive a CLE verification form that you can fill out so you can get CLE credit for this. The CLE code for today is SS, as in Seyfarth Shah, 7635. Once again, that's SS 7635. So with that foundation that Dawn laid out for us, we want to kind of explain to you what this means going forward. You've got all of the fundamental tools to think about the considerations. There's no one size fits all for your company or companies across the board, but what does that mean for you moving forward with all these changes in state laws? Maybe you want to implement new agreements for new employees that you're hiring. Maybe you're looking at some of your agreements that you've had in place for 20 years and they're just not keeping up with the times. And in the event, you know, with more employee mobility that's happening as time goes on, it's not the days of yore where everybody was working at the same company for 30, 40 years and getting a gold watch upon retirement. So what are the thoughts that you need to be considering when you are thinking about implementing or creating new agreements for your workforce? And given the statutes that we've kind of previewed for you, what are the ramifications for you if you're not compliant? Of course, Dawn previewed for you, you know, what is your risk tolerance, but what is the end goal for you in thinking about protecting your goodwill and your assets, whether it's trade secrets, whether it's a stable workforce and making sure that you're not having a mass exodus of employees that are following somebody that leaves to go to a newer, bigger, better company, or it's your client base, it's your customer base. What is the secret sauce, or what makes your company tick that we can help you protect? And what are the things that you need to consider in light of all these changing state laws? And briefly, we'll touch at the end a little bit about federal considerations, because not to be left out, the federal government and DOJ is also monitoring and seeking to protect employees and is cognizant of what is going on with non-compete legislation among the states and wanting to make sure that it's also considering employee mobility and protections, and also largely in the Sherman Act sense, making sure there's no anti-competitive behavior that's going on in a company-to-company type situation or with respect to the employee workforce. So with that, why don't we go ahead and move to the first slide of that section. Thank you. So as Dawn previewed, new states, or many states, are coming out with new statutes. Does that mean you need to roll out new non-competes for new employees only? Yes and no. Again, there's no right answer. Many state laws are not retroactive, so it doesn't mean that once a new law goes in place, say January 1, 2023, all previous agreements that you had in place are null and void. That's not what that means. But again, if you're looking at your agreements and you see that some of them are dated, and perhaps you have somebody that started off in sales and then moved to a higher level C-suite or executive position, maybe it's not amply protecting what the interests are of the company. Maybe that employee got a significant title change, salary and bonus, even stock options, and needs to have restrictive covenants that match those types of ascension on the corporate ladder. It's not a requirement, but it depends on the company, and maybe you look at them every 5 years, 10 years, but it's something to consider as new statutes come out and as new states are becoming aware of this and rolling it out. What is the best protection for your company? So as I mentioned, you may have a situation where these new statutes are coming out, and a lot of times employees are saying, well, my agreement's really old and not very good. It's overbroad. It doesn't have any geographic limitations. It's not based on the work I do, or it's for 4 years, and that's probably not going to be held up by a court of law. And the company realizes it and wants to have new agreements rolled out. Well, what are the solutions to that? Obviously, there are all these considerations with notice, allowing an employee to have counsel to consider it at least 14 days, and perhaps additional financial consideration. And then, social media, employees talk at the water cooler, that spreads like wildfire. If employees are realizing that they don't have enforceable agreements, what is that going to mean for the workforce? And again, there's the sliding scale approach for your company and what is important to you. It makes more sense maybe to have higher level executives, client-facing employees have restrictive covenants, whereas lower level employees that don't have the kind of exposure to the protectable interests that the company is interested in protecting, they might not need those types of restrictive covenants and might just need something that is a non-disclosure agreement, and making sure that that type of information is protected. I say that with a caveat and carve out, given the work that Dawn and I do, because more and more, especially with remote working in a COVID environment, especially with employee mobility, and no matter how much you educate your workforce, employees still believe that they're entitled to take the work that they worked on when they worked for your company. And they put things on USB drives and they email things to their personal email account and think no harm, no foul. And one of the things that you have to show if you're trying to get that back and then you end up in a courtroom is that you've taken adequate steps to protect that information. You may want to have, as a baseline effort is to have non-disclosure agreements across the board and some type of confidentiality and privacy policy in place. That's another topic for another day. We're happy to help on that too, but I just wanted to mention that. So for new agreements, if you have to roll that out and you have a giant workforce across multiple states, what is that going to look like for you, and how are you going to implement it in a way that is effective and make sure that you're getting ahead of these state law changes? What are the ways to do that? Well, it has to be controlled and precise, because you understand that there's a huge administrative task that goes with it, and making sure that these things are being uniformly rolled out and uniformly applied, and that you are taking care to keep track of what employees are subject to these and how they are signing and returning them in compliance with the notice period, in compliance with whether or not additional consideration needs to be sent out, and whether or not you have met the checklist for all of the things for that employee, depending on where they are and what state is applied. It's a lot, and we understand that. One of the things we always say, and it may seem very basic and obvious, but make sure that all the pages are required, or excuse me, are returned, initialed, signed, and put in a safe place for record keeping purposes. Personally, from my experience, I had a case in the Western District of Michigan several years ago. The employee only returned the signature page, not the entire document. And that was placed in the personnel file, and roughly the entirety of the lawsuit was focused on this employee claiming he never signed a non-compete. It's just a random signature page. We don't know what it ties to. We don't know what the terms are that apply to him. The company ruled out different non-competes. And there's nothing that's enforceable as to him. You don't want to be in that situation. You want to make sure that you understand exactly what provisions are applying to this employee or set of employees, especially given when you're in a multi-jurisdictional situation. They were given all of the, as Don appropriately phrased it, bells and whistles to know what exceptions apply and exactly what terms apply to that employee. It's just maybe an extra administrative headache, but it protects the company in the long run and is just really good record keeping practices. And then on top of that, you've got differing states with different timing for review and notice and acceptance of terms. Some states are 10 days, some states are 14 days. Employees may want to return it sooner and just sign it and get it done with, but you want to make sure you have language saying that they've had adequate time and they're not, you know, in any way prejudiced by returning it early, and that they've had the ample time to consider it. They're not being rushed by the company. Here's a big one. Consideration. It's really important that while you consider giving them specialized training, access to confidential information, a title change, and an increased salary, is that enough under state laws? And for example, I work in Illinois. The new Illinois statute that came out has many new facets to it, including base salary benchmarks for what's considered enforceable. And on top of that, the legislature in all its wisdom just said financial consideration to support it if an employee leaves less than 2 years of employment. So if you hire an employee and they meet the minimum threshold and say make approximately $85,000 a year in a sales position, but they leave before 2 years of employment, and you as a company have not given them additional financial consideration, game over. That's it. It's not enforceable. And then all the effort is for naught. Well, as it turns out, it's still a new statute. Of course, the legislature did not define what constitutes adequate financial consideration, leaving everybody to guess. And because it's so new, the courts haven't really interpreted it or deemed what it is. Of course, there's a sliding scale approach. If you have somebody that's making $500,000 a year and you give them $100 to sign this, that's probably not going to, you know, cut the cake. Alternatively, if you have somebody making $85,000 a year and they get a $1,000 signing bonus and also have access to specialized training, customers, specific confidential information, that will likely carry the day, and you will be able to show that in a court of law that you've met all of the requirements of the statute to show that it's enforceable. You don't want to be in a situation where you're playing cute with budgetary concerns and trying to give the least amount of money, because in the long run, you might have an employee that says, I got $200, but I make $500,000 a year. That's not sufficient to enforce these provisions against me when I left after a year and a half, and a court would maybe agree, and then all of that work was for naught. It is important to make those considerations going forward because it can be a sliding scale approach. Again, it doesn't need to be a base amount for everybody, but what is the company's risk tolerance, and what are the budgetary concerns that come with that? Because so many states are saying continued employment is not enough for such an important part of an agreement. And so there needs to be a plan in place ahead of time about where's that money coming from. It doesn't grow on trees, and it has to be budgeted for and made sure that the company can accommodate those types of rollouts for not only new employees, but if it's making existing employees sign, what will that look like? And There are different ways to fit the mold for that, but it's important to outline that in the agreement, especially for new agreements going forward. A lot of courts don't want to say, I'm going to look outside the four corners. If you come in and say, oh, but we also gave them, you know, a trip to Fiji, and they won this, and they had extra time on their lunch break or what have you, the courts aren't really going to consider it, and you want it expressly outlined in your agreement what that consideration is and how it's tied to the restrictive covenant, so there's no confusion going forward. Then I mentioned that you can have employees talking at the water cooler. What happens if they all get together and say, I don't want to sign this. I don't want to be tied to this. This doesn't interest me. I've already got an agreement in place. What is the company going to do with that, and how are they going to face it? Will there be employee turnover? Will you be willing to say, okay, well then, you know, this ends our employment relationship. Thank you very much. Are you making sure you're complying with labor and employment laws if that happens? Are they an at-will employee? Are they not an at-will employee? There's a lot of considerations going forward. And again, this is part of Dawn's preview. What is your risk tolerance? What is your long-term goal? This isn't something that you would take lightly or roll out on a whim. There's a lot of considerations, but what is the company's answer if you have an employee that refuses to sign? Maybe it just means they want more money or a title bump, and can the company accommodate that? There are a lot of obviously changing or scenarios and factors that come in, and we want to make sure that we're considering all of those before these are rolled out. Can we go to the next slide, please? Thank you. So what does this mean? There's states that do blue pencil, there's states that do judicial reformation, there's states that do red pencil, and of course, esoteric legal terms, we can't help ourselves but have them. But what do they mean for companies that have multi-jurisdictional employees with these different non-competes, and how can we make sure that we're addressing it? Well, that means let's draft these agreements proactively and make sure that we're hitting all of those items on the checklist that we're talking about, and making sure that they are as narrowly tailored as possible to protect the company's interests. No more, no less. We don't want to be cute because we don't want to count on the expectation that a judge would take the time to say, okay, I can just, you know, do a carrot and add this in, and then everything will be gravy, and I'm going to help the company. More and more courts, following the trend of legislatures, are wanting to be protective of employees. And if the company isn't taking the time to make sure that its agreements are appropriately drafted to protect its interests, the court isn't necessarily going to take the time to do the extra step and do the work for the company. So some states allow blue pencil. What does that mean in terms of comparison to the other things? Blue pencil means the judge is going to add its own terms and say, okay, well, I see that you've got a non-compete for a competitor, but I'm just going to insert a carrot that says doing the same type of work that you did for this company in the past 18 months of your employment, and then everything else stays the same to make it a little bit more narrowly tailored. Some states allow blue pencil. What are those states? Arizona, this is just example, this is not exhaustive, of course, and then you can see our handy dandy 50-state reference that lists out whether there's blue pencil or reformation. Arizona, Connecticut, Indiana, they allow blue penciling of restricted covenants. Of course, this is discretionary. Just because it's allowed doesn't mean the court's going to say, oh, I'm going to do this and add my own terms. You always run the risk of a court throwing it out altogether. The most restrictive approach is the red pencil doctrine, where they say the entire thing is struck down because if any part of it is invalid, they're not going to take the time to review and enforce it. That's a you problem, not a court's problem. And that's obviously very extreme, and you don't want to be in that situation, but there are states that take that approach. Arkansas, Nebraska, Virginia, for example, those states listed there adhere to the red pencil doctrine. What's the difference between blue penciling and reformation? Blue penciling, a judge is going to carrot, add its own terms in. Reformation, a judge is going to rewrite it. and just say, I'm going to throw the baby out with the bathwater. I don't think this is good. I'm going to start, but you've met these minimum requirements elsewhere, and I'm going to help you along. This is very, very rare in my experience, and judges do not want to help. Well, they're very busy and overworked as it is, but don't want to take the time to rewrite an agreement that could have been written properly in the first place. And so state and federal courts are trending away from reformation and blue penciling and refusing to modify as written. They don't want to, or they don't have the time, or a combination of all of it, say that that's not for them to do, that's the company to do, they're in a better position, and if they haven't done it, too bad, so sad, it's out. And so we've seen that a lot in Illinois, and we've given it a cite from a case here back from all the way in 2007, where Illinois courts are saying it's tantamount to us rewriting a whole new contract for you. And if you count on that, if you count on judicial reformation or blue penciling, then companies are not going to have the incentive to draft them appropriately the first time around. They're going to make them as broad as possible in the hopes that it never gets to litigation. And then, you know, crossing their fingers, they've got an employee that's under the restrictions of these incredibly overbroad restrictions. They don't either have the resources or attorneys to help protect them and make sure that they're being challenged in the court of law. And then the company, big bad company in that situation is winning, and it's not fair to the employee. Alternatively, you can have an employee that does have the resources or does challenge it, or their new employer challenges it, and then a court says, we're not going to change this for you. You've made it overly broad. You were expecting to come in and for us to do the work for you. We're not going to do it. And then the employee wins, right? They don't have those protections against them. And again, now you've got a situation where you have other employees, they chat, they know, and they say, well, guess what? I have the exact same agreement, and that's not going to be a problem for me because this court threw it out. You don't want to be in that situation. You want to make sure you're being proactive, not reactive, and that you're making adequate protections and taking the right steps ahead of time to ensure that this is going to be an ironclad agreement, or at least as ironclad as possible, in the unfortunate event that you end up in litigation and have to be in a court of law, standing behind it and making sure that, you know, the court understands why it's important that it's enforced as written. Next slide, please. The much hated things that Don already previewed. What are the consequences of not adhering to these new state laws? Again, it really depends on the state laws that are in place. The most draconian, of course, is recently with the Colorado addition to the statute, which has fines and criminal penalties. That's not great. It was certainly a shock to most of us when it came out, and companies are worried and wanting to make sure that that doesn't apply to them. Personally, I have not seen a company fined or had experience with this being enforced against a company, but there's a first time for everything, and there's no reason to play fast and loose. This goes back to the previous slide by making sure that you're going through the state law statutes and making sure that you're adhering to the most basic requirements of the state and ensuring that you're protecting your company assets, whatever those may be. Alternatively, Illinois, as I mentioned, came out with a new fair labor statute dealing with a host of new provisions, including income benchmarks and notice provisions, and the elusive additional financial consideration that I mentioned to you. We have no idea what that means, so it's anybody's guess. But if you have a covenant that isn't compliant with the new state statute, and it doesn't meet what is required under the statute, it can be void and unenforceable, and the whole thing goes out the window. You don't want to be in that position either. And again, another draconian one would be Washington, which has $5,000 minimum baseline in damages to employees, notwithstanding reimbursement of attorney's fees and costs, if the court has to engage in that judicial modification process knowing ahead of time and showing companies that they should be incentivized to draft it as nearly as possible the first time around. Next slide, please. Dawn touched on these, and I won't exhaust it, but there's fee shifting provisions that have teeth. You don't want to be in a position where you're going to have to litigate this and not only pay your own attorney's fees, but have to pay the attorney's fees of an employee that is potentially violating those restrictive covenants. That's an added, pinch to the budget. It's real money when you get into litigation. You don't want to be in a position where you could be liable for those types of things. It's important to know whether or not those statutes, such as California, Illinois, and Nevada, these are just a subset, have those types of fee shifting provisions, which are mandatory, and courts won't hesitate to impose those, especially in a company versus former employee situation. Next slide, please. And as I mentioned for you, not to be remiss, we wouldn't leave out the federal system, which is constantly monitoring this and looking at the fact that states are changing and instituting statutes to protect their employees. Well, what is the federal legislature doing, and how are they addressing this? In February 2021, there was a Workforce Mobility Act intending to address the limited use of non-compete agreements. There's the Freedom to Compete Act in July of 2021. Again, and this is what we previewed for you. Do you need these intensive restrictive covenants for entry-level or low-level workers? Is it necessary that a janitor or administrative assistant have a restrictive covenant telling them not to solicit customers' employees? Probably not. Would a non-disclosure agreement do just fine, or do they need one at all, depending on their position and their responsibilities? Then there's Biden's Promoting Competition in the American Economy order that was released in July 2021. I cannot tell you how many phone calls I received. I'm certain Dawn is the same, where people thought that all non-competes were eradicated, null and void, and that their workforce was free to go on a frolic and detour when this came out. It's not what it meant, but they are monitoring it and wanting to make sure that they are, quote, curtailing the unfair use of non-compete clauses. And again, just protecting employers and making sure that everything is fair in the workspace. And going to the next slide, please. Similar type of work, the DOJ and the FTC, they're monitoring anti-competitive behavior in the business-to-business no-hire agreements or companies using non-competes. How are they being instituted and rolled out, and what does that mean for protection of employee mobility and the workforce overall, especially in today's economic climate? What does that mean, and what are those considerations? Same with the Department of Treasury, the report that came out earlier this year, and summarizing considerations that employees are doing. Nothing earth-shattering here, nothing that was a universal mandate across federal law to change or prohibit or ban non-competes, but they want to be part of the conversation. They are part of the conversation, and they're monitoring what's going on. And it's important that companies are also aware of that landscape across, not only in a state-specific situation, but as employees, or as companies do things across state lines inherently, and companies are working remotely, and employees transition. We want to be mindful of the fact that lots of states are implicated, federal law may be implicated, and how can the contract be proactively drafted and making sure that the company is protected. With that, I did it with 2 minutes to spare, so I'm pretty pleased with that. However, we've left very little time for questions. Again, a plug for our 50-state desk reference, which is a really great guide listed out. There are contact information, but it goes across blue pencil, additional consideration, what is needed, what are the statutes that apply, who does it apply to. It's a great thing to have on hand. We do this all the time. This is not old hat. It's constantly changing, but we're monitoring it. And as John previewed, we are looking at your questions. If we don't answer them today, we will answer them and get back to you. But please feel free to reach out to either Don or myself or anybody in our group. Our contact information is there, and you got CLE today if nothing else. So we hope this has been valuable to you. And with that, we just want to thank you very much for your time, and we hope to hear or see from you again.
And I just very quickly wanted to say we got a ton of questions, which was amazing. And I feel bad that we don't have time to respond to all of them. We will reach out to you. One thing I really quickly wanted to address, because I saw, I think, at least 3 questions about e-signatures. All states permit e-signatures. Personally, I think DocuSign is a great method because there's a transaction, ledger basically that shows when the person saw it, when they signed it. I wish I could tell you that no employee has ever argued that the DocuSign ledger or the e-signature is, not their signature. I have seen that, unfortunately, but I'll say this. If they're going to argue that a DocuSign signature is falsified, they're going to argue that their witness signature is falsified too. So I think DocuSign and e-signatures are actually a better method. I just wanted to address that because I know I saw several comments about that. Again, we're out of time, unfortunately. We will reach out to you in response to the questions that weren't asked. But again, thank you so much for joining today.